may be seated.
All right, good morning, ladies and gentlemen. Okay, we're resuming in this case of State versus Brendan Castiglione. This state had rested as of last Friday, and then we adjourned early, and we are resuming. Does the defense, how does the defense want to proceed?
Your Honor, the defense rests.
Okay. All right, the defense is rested. We are going to proceed with closing arguments then.
Brandon Castiglione is not guilty. The police jumped to conclusions. Within 2 minutes of the first officer arriving on the scene, Brandon was in handcuffs in the back of a police car. And because the police jumped to that conclusion, they did not do a thorough investigation. And as you've heard, they only looked for evidence that pointed at Brandon. I want to talk to you about some of the ways the police did not do a thorough investigation. Evidence that they should have collected, but that they simply did not. So, what did you hear about that? Well, you heard there was a cell phone right there on Brandon's bed. See multiple pictures of it. But you heard the police didn't collect that. You heard Trooper O'Leary testify about the kinds of information that can be on a cell phone. GPS data, calls, texts, all kinds of things. You heard him explain how they go about the process of applying for a search warrant, what they have to show, that it's likely that there would be evidence related to the case. They had Brandon as their suspect. His GPS records of where he was that day, of course the judge would have signed off for that. The police could have had that. All they had to do was ask. But you heard, they didn't bother. It wasn't part of their application for a search warrant. And you never heard that any officer ever asked Brandon for permission. You did hear that's another way to search for a phone, or to search a phone. In fact, that's what happened with Luis Garcia's phone. The police searched that because they had permission. They didn't ask Brandon for permission. They didn't ask for a search warrant. They didn't bother looking for the most basic thing that was right there in front of them. Well, what other ways did the police not do a thorough investigation? Did the police not obtain important evidence and information that they should have? You heard when Mark Castiglione, Brandon's father, got on the stand and testified. He said he thought Brandon had a car that day, and then he wasn't sure, and maybe it was returned earlier, and he really didn't know. Why didn't the police find out back then whether Brandon had a car available? Whether Brandon could have gone for a drive? Whether Brandon could have gone anywhere? The police did nothing to investigate where Brandon was on October 1st. You didn't hear any police officer tell you that they knocked on all the doors on that street, that they asked, hey, did you see anyone come or go from number 15? I mean, we're talking about basic things that you should have heard. Where was any evidence of any of that? The police did not do the most basic things in investigating this case. They didn't do it because, again, within 2 minutes, they had decided it was Brandon. He was in handcuffs in a police car. Now, I've explained to you how the police jumped to the conclusions. The government wants you to jump to that same conclusion. You heard in the government's opening statement them say how simple this case is. One bullet, one gun, one man. One man that they can't put in the house at the time of the shooting. One man that they can't say fired a gun that day. One man who had no reason to shoot his friend. What the government doesn't want you to think about is 4 very important words in this case. Beyond a reasonable doubt. You've heard that several times throughout the case. The government has to prove their case. Brandon doesn't have to prove anything sitting there. The government has to prove that Brandon did what they're claiming he did. They have to prove that to you beyond a reasonable doubt. I want to talk about those 4 words for a minute. You know, your jury service started actually before you ever saw Judge Ruoff. Started with that video that you watched first thing when you came in on jury selection day. And that video introduced you to some important legal concepts, including different levels of proof for different kinds of cases. One level of proof is called proof by preponderance of the evidence. Think of it as the scales of justice, and if they tip ever so slightly one way or another, that's proof by preponderance of the evidence. That's all it takes in some kinds of cases. But that's not the standard that you're applying here. There's another, higher standard that applies to other kinds of cases. Certain kinds of cases have a higher standard called clear and convincing evidence. If the evidence is clear, if you are convinced, that is not the standard that you are applying. The highest burden, the highest standard, I should say, that our legal system has. Proof beyond a reasonable doubt. And the judge has told you, if you have a reasonable doubt, you must return a verdict of not guilty. And I want to talk to you for just a minute about why it's that way. It's that way because of our constitutions, both the New Hampshire Constitution and the U.S. Constitution. And that standard was written into those documents. And the great scientist, statesman, founding father, Ben Franklin, said it far better than I ever could. So I'm going to read a quote from him. He said, that it is better 100 guilty persons should escape than that one innocent person should suffer, is a maxim that has been long and generally approved. That's why it's written into the constitutions, for this highest standard, proof beyond a reasonable doubt. I want to talk to you about another important moment in this case, one you may not be thinking of. On Tuesday of last week, not at jury selection, but right before the trial began, on Tuesday afternoon, each one of you stood in that box. Each one of you raised your right hand, and each one of you swore that you would follow the judge's instructions. You took that oath. And the judge has told you, if you have a reasonable doubt, you must find the defendant, Brandon, not guilty. Now, the judge will tell you that your verdict has to be unanimous, and that's certainly true. He'll also tell you that your verdict has to be your own individual vote. And I want to talk about what that means for just a moment. Because you don't all have to have the same doubt. If you doubt because the police didn't get the phone, if you doubt because Brandon had no reason to kill Luis Garcia, if you doubt because the police didn't test the gunshot residue kit that they took, if you doubt for another reason, that's okay. You don't all have to have the same doubt. If each of you individually has a reasonable doubt, your individual vote is not guilty. And if each of you vote not guilty, that is what is meant by a unanimous verdict. I want to talk about some other ways that the police did not do a thorough investigation. And that, ladies and gentlemen, one of the ways is the gunshot residue that they took a kit for, that they collected, never tested. You heard about the warrant for Brandon, for his body. You saw all these pictures, a couple dozen or more, documenting everything they did, documenting what he was wearing, documenting each layer of clothes they took off, documenting his hands. You heard. The police got a warrant for all of that because they knew it could contain important evidence. You heard they took swabbings of his hand for completing a gunshot residue kit. You heard that someone who fires a gun will have residue on their hands. The judge signed off on that warrant. The police requested that warrant. They did that for a reason. And then they didn't bother to test it. Could have shown that Brandon didn't fire a gun that day if they had just bothered to test that. But it wasn't just the gunshot residue kit from his hands that wasn't tested. It was also his clothes. All of those were collected. All of those were sent to the state lab. Those could have also been tested for gunshot residue. Again, could have shown if Brandon fired a gun. Could have proved that he did not fire a gun. The government didn't test that. You know, the only evidence you heard about actually testing for gunshot residue, that was from Dr. Duvall on Luis Garcia's hands to eliminate the possibility of suicide. I want to talk to you for a few moments about some things I think the government may try to argue to you. After I'm done talking to you here, they're going to get up, they're going to have the opportunity to talk to you too. I don't know exactly what they're going to say, but I have some guesses. And I want to talk about some things they're likely to say and why you shouldn't be persuaded by what they say. You know, at its simplest, the government wants you to believe that it must have been Brandon, he must have shot Luis Garcia, and he must have just stayed there and prayed for several hours. And you heard that they may try to tell you that you should believe that. They may try to say, well, Brandon didn't go many places. But think about what evidence you actually heard. You heard, again, from Mark Castiglione, Brandon's father. What did Mark tell you? Mark told you, I actually don't know Brandon's routine when I'm at work. I'm not there, I don't see it, I don't know what he does during the day. He did know that Brandon sometimes went to events at churches other than New England Pentecostal, that he had multiple churches that he was involved in, went to. Did Brandon go to some event at some other church that day? Did Brandon drive the car that Mark thought he may have still had that day? Mark certainly did not say that Brandon was home. You know, the government may also try to say, well, it must have been Brandon. The doors were locked. Who else could it have been? How could anyone else have gotten inside? So let's talk about that for a moment. You heard at least one other occasion Luis Garcia let someone into the house. You heard. He had his wife Patty come over to see his painting. So you know at least one time Luis let someone in. He could have let someone else in that day. Mark said he wasn't aware of Luis ever letting anyone in. But that again, and again. But here's the other thing about the doors being locked. If Brandon left, went somewhere, he comes back. He locks the door. He takes his own house. And he starts praying. Well, he kept the gun locked up in his room, in that file cabinet. Well, let's talk about what the evidence actually was. First of all, this is there on top of the file cabinet. Would not have been hard for anyone to pick that up and use that. And that's if the cabinet was even locked. Because what evidence did you actually hear? Again, you heard from Brandon's father, Mark. Mark said he wasn't sure if Brandon kept that cabinet locked. Mark said he was still keeping the gun in its case in that cabinet. He didn't know. What you do know is that there's another place that that gun could have been, and that is in a bag in the living room. You know it could have been there because you know guns were in that bag. The bag has a magazine. The bag has spent shell casings. Clearly, that bag was used to store or transport guns. That Glock could have easily been in that bag where anyone could get to it. The government may argue to you, well, Brandon didn't call 911. That's true. He didn't. There's no evidence of how long Brandon was there after finding Luis Garcia before the police arrived. You heard Brandon is a deeply, deeply religious man. You heard he often prays. You heard that's very common for him. You heard that when he prays, he shuts out the world. Ladies and gentlemen, it is not surprising that when he finds his friend killed, shot in the head in his own house, he comes back, finds that body. It's not surprising that for Brandon, what made the most sense was to pray. Certainly, would some other people have called 911? Yes, I think many, many would. But Brandon, what made sense to him was to pray. The fact that he did not call 911 does not make him a murderer. You know, one other thing I think the government may point to try to prove their case is fingerprints. So let's talk about those for a minute. You heard there were 2 fingerprints found on Brandon's gun. Now, again, it's his gun. He owned it. It's not surprising that his prints would be on it. And you heard the fingerprint expert, Rachel Martinez, tell you she can't say anything about the age of those prints. She can't tell you when those were left on the gun. The only thing she can say is that those prints were left sometime after the gun was manufactured. That's all. Those prints could have been there for weeks, months, years. Those prints don't tell you anything about whether Brandon fired that gun that day. The judge at the start of this case gave you some instructions. And one of the things he talked about was circumstantial evidence. And he described that. He talked about how, you know, if it's dry outside when you go to sleep and it's wet outside when you wake up, that's circumstantial evidence that it rained overnight. It means no one saw it happen. That's what this case is, ladies and gentlemen. We have a purely circumstantial case. There's no evidence directly that Brandon shot anyone. There's some circumstances that the government wants you to believe indicate that he did. But the judge gave you one very specific, very important instruction that applies to circumstantial evidence cases. I want to get this right, so I'm reading directly from what the instruction was. And the judge told you that to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other reasonable conclusions. This means that if, from the circumstantial evidence, it is reasonable to arrive at 2 conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. Again, that's the judge's instruction, the instruction that you swore that you would follow. There are multiple reasonable conclusions based on the circumstantial evidence in this case. And one of those reasonable conclusions is that Brandon did not do it. It's reasonable to think that Brandon might have gone out that morning. And because of that, you must find Brandon not guilty. It's reasonable to think that maybe Garcia had someone over. And because that is reasonable, you must find Brandon not guilty. It's reasonable to think that the gun may have been left in that bag in the living room where anyone could have found it, picked it up, and used it. And because that's reasonable, you must find Brandon not guilty. Now, I want to talk to you for a few minutes about that gun. You heard about how this was tested. You heard about what information the lab had when they tested this. Now, you heard from Jill Terrio, the firearms expert. She talked to you about a training she went to about cognitive bias and how that can be unconscious, how that can, having information about a case, can unconsciously bias or taint, influence conclusions that are drawn. She said that's especially important in fingerprint cases. She talked to you about a study that she had heard about where fingerprint examiners were given 2 sets of prints to compare. And then a few weeks later, the same examiner was given the same sets of prints but given different information about the case, and how that often led them to make a different conclusion. Either that something was a match when they previously thought it wasn't, or vice versa. And what did you hear from the actual fingerprint examiner here? Rachel Martinez told you she knew Brandon was a suspect. She knew the gun was found in close proximity to him. That is information she should not have had, information that influenced her conclusions. But it's not just that information that was given to her. You heard more than that. You heard how she had conversations with the lead investigator in this case, Trooper Stephen Sloper. Now, Trooper Sloper said that she was to look for evidence that would connect that gun to Brandon. And Trooper Sloper told her, if you find a connection, don't run any other tests. He specifically told her not to have those 6 swabs that were taken from the gun. 6 swabs of touch DNA. He said, don't test those. Ladies and gentlemen, the government wants you to convict Brandon without ever hearing from the lead investigator. And why didn't the government call their lead investigator? Well, you heard that too. The lead investigator, Sloper, said he was checking with the Attorney General's office and would get back and let the lab know what to test and what not to test. The very office that is prosecuting Brandon made the decisions not to test evidence that could have proven Brandon did not do it.
Objection, Your Honor. Facts not evidence.
Well, the jury's recollection of the facts will control.
Very well. Thank you.
That's why you didn't hear from Stephen Sloper. And just to talk about that just a little bit more, you heard there were 6 swabs. 6 swabs that could have each had touch DNA taken from the grip, and there were swabs taken from the trigger itself. That evidence was not tested because prosecutors didn't want it tested because it could have hurt their case. Want to talk to you about one other very important thing in this case. Something that, quite frankly, makes absolutely no sense whatsoever. You heard testimony from Trooper O'Leary. He was the trooper in charge of actually physically collecting the evidence. You heard a lot of exhibits were labeled JGO 1, JGO 2, JGO 75, whatever the numbers were. And that JGO, those were his initials. Now, what did Trooper O'Leary tell you about the gun? Trooper O'Leary told you that he collected that gun, and he told you how many bullets were in it. And he even has it in writing. He testified to it. He has it in writing, State's Exhibit 114. I'm going to ask that you take a close look at this when you're back in the jury room, talking, deliberating about this case. Because what does this say? It says that there was 1 round in the chamber, 15 bullets in the magazine. Ladies and gentlemen, you heard from Jill Terrio. The magazine had a capacity of 15 bullets. So I guess the government wants you to believe that Brandon, sometime before 9:30, shot his friend for no reason, went, did one more bullet into the gun, then put the gun on those plastic shelves in the hallway, then went back into the room where Luis Garcia's body was, and then prayed. That makes no sense whatsoever. That is a huge reason to doubt the government's case. Why on earth would anyone do that? Brandon could have gone anywhere that morning. That is a reason to doubt. There is no physical evidence that Brandon fired a gun that day. That is a reason to doubt. Brandon had no reason to shoot his friend. That is a reason to doubt. There are many, many reasons to doubt the government's case. The government did not prove its case because it could not prove something that did not happen. Brandon Castiglione did not shoot Luis Garcia. Brandon is not guilty.
Your Honor, could approach briefly, please. Yes, ma'am.
Your Honor, I don't know if you want the jury to just stretch for a moment.
He's going to set up. Folks want to stand up for a second. More than welcome to.
Thank you, Your Honor. When a trial concludes, we say that the case is now in the jury's hands. And when a person gets married, a ring gets placed on their hands, and it's worn as long as both shall live. And when a son is born, a family first looks at the hands, and the family members say, what? It's okay. He's got 10 fingers, he's got 10 toes. Well, last Tuesday we told you that Luis Garcia was killed by the defendant, Brandon Castiglione. And that this trial now concludes, the case will be in your hands. And 4 days before her wedding anniversary, Patricia Garcia found out that her husband was not okay. And now that ring on her hand was from a man who was never going to pick up that phone again. And a family, a sister, a grandmother, Danielle Padovano and Francis Pestana, they saw what their brother and grandson had done with his hands. And it was not a dream. It was a nightmare. Simply put, there is no mystery who the murderer is in this case. It's the defendant. The same man locked inside his house with Luis and no one else there but the two of them. His pistol locked inside his cabinet. This gun that was used to kill Luis Garcia by shooting him in the back of the head. And in the process, left fingerprints on it. His spent bullet casing on the floor, the one that came from his gun. Loaded from his ammunition from the top drawer of his bedside cabinet. The same as the only bullet casing in the room where Luis was shot and killed. And from this casing, his bullet on the floor. The one missing two pieces that was still in the back of Luis's neck. The bullet fired from that gun. And the only bullet in the room. It wasn't self-defense. It wasn't an accident. This was not a botched investigation. And it wasn't some mystery man like the defense wants you to speculate about. What you just heard from the defendant in openings just now was speculation. And speculation is not evidence. Evidence doesn't come from this podium. Evidence comes from that witness stand. Evidence comes from the exhibits, the stipulation, and what you saw in this courtroom. They want you to ignore the evidence and look anywhere else but where all of the evidence points to the man who shot Luis Garcia with his Glock 9mm pistol, serial number TSA 446, that was loaded with Fiat all-copper 92-grain ammunition. The man sitting right there, Brandon Castiglione. Luis. He was a father, he was a husband, a friend, a counselor, and a minister. And his hands were at work constantly. And you remember hearing that when his asthma didn't let him go in and out of those refrigerated meat packaging and seafood packaging plants anymore, he had to switch over to painting. He started doing finish painting. And Luis was also a minister at New England Pentecostal. Not an ordinary minister. He built with his hands. He built a sign for the church. He cooked. He did security for the church. You heard how he sat and spoke with others, counseled them through the best and the worst moments of their lives. He attended services on Sunday, Bible studies during the week, Monday prayer sessions, some of which were led by Minister Eddie. And in addition to all that, we heard how Luis took the time to try and counsel the defendant. The defendant's behavior leading up until the point of the murder, you heard, have become and has caused a concern in the church. This caused Luis to have an interest with this defendant that was beyond just being friends with each other. But as someone in charge of church security, he now had to have the security of others in mind. Luis began doing work at where the defendant lived, doing things like stripping wallpaper and painting for Mark Castiglione, the defendant's father. He had been doing it for more than a week before the defendant shot him. So Brandon knew that Luis was going to be coming over that day. Luis got into the house that day the same way he usually did, by using the key that was left for him under the mat on the mornings that Luis would come to work. A key that otherwise wasn't there. It was just for Luis on the days he was coming. You heard that from Mark Castiglione. No one else knew it was there. Even Mark's daughter, Danielle Padalano, and his former in-laws, Fran and Jeff Pestana, didn't know that it was there when they came over later that day and tried to get a hold of anybody in that house, desperately trying to reach somebody inside. On October 1st, 2019, Luis started his day at home. We know from Mrs. Garcia he left the house around 8 o'clock in the morning, alone. We know his phone logged the last call that he ever had was somewhere between 7:45, the call being made at 7:45 in the morning to Minister Eddie. With his drive from Manchester to 15 Richmond Drive in Londonderry, common sense is going to tell us that can't be more than 20, 30 minutes tops. So on this Tuesday morning, Luis has hung up with Minister Eddie, arrived at the house, parked his Subaru in the driveway, the only car that Frances Pestana ever sees there, when she arrived later and went inside. Car in the home that has no garage, as you remember from reviewing through the photos of the different windows and entrance and exits. Has no garage. No other car seen there. Luis gets there, parks, and goes inside. A little over an hour later, maybe even less, this defendant has shot and killed Luis. We know that from Luis's phone. We don't know what caused it to happen in that hour, but we know something was different. We know something was wrong. You've heard testimony from multiple witnesses that Luis regularly picked up his phone when people called. Mark called him on that morning, on his morning break, just like he ordinarily would. 9:31 a.m. All went through. Brother Mark tried to call, missed call, about 9:30 a.m. This was what Mark usually did when Luis was going to be there. Brother Mark called, but very unusually, Luis did not pick up, because Luis was likely already dead. Mark didn't know that. Maybe Luis was busy working or turned his ringer off. Mark did what? Tried the defendant. Very next call, very next minute. The defendant did not pick up his phone either. Not all the rest of that day. The phone records prove that Luis was dead a little over an hour after getting to 15 Ridgemont Drive, because otherwise Luis, as he ordinarily did, would have picked up his phone. And the defendant didn't pick up his phone either during that same time period on forward, because whatever motivated the defendant to go through the process of getting his Glock from the locked cabinet, walking up behind Luis, raising his arms, pointing the Glock at the back of Luis's head, and pulling the trigger, knowing that Luis would die, when he shot Luis from behind, That must have taken place within that hour too. Big question. The only real mystery in this case is, why did the defendant do this? That's the mystery. And one tragic truth that every single one of us realizes, whether we've said it out loud to ourselves or not, whether it's in our own lives, our friends' lives, our families' lives, what we see on the news, one tragic truth is that every single day, people who love each other hurt the people that they love, or the ones who are trying to love them. And sometimes they even kill them. Sometimes there's no reason. And sometimes there's no good reason. Sometimes there's no reason at all. Human beings, we're not machines. Human beings don't do exactly what we expect them to do. The defendant certainly didn't think that Luis would see him coming. That's why he shot him in the back of the head. We'll never know why the defendant murdered Luis. We only know that he did. We only know that he shot him, and he knew it would kill him. And the charges in this case don't require the state to prove motive of why he killed Luis. That's important. That's worth repeating. Motive is not an element of the crime of murder. It's impossible to read a person's minds. We can speculate why he did it, though, can't we? Was it an argument over religion? Over Luis's role of the church, overseeing security, stopping the defendant's behavior there? Something from the midnight prayer session the night before, maybe. Why he called Minister Eddie? Was it resentment of the counseling that Luis was giving him and trying to tell him what was and what was not? A disagreement over what the word was? Was the defendant contrasting his own situation and coveting Luis's stable life and faith? We don't know. And we never will. And as much as we want the why, and why do we want the why? We want the why because it makes sense of the senseless, right? The why isn't something that the state has to prove. Just the who. Who killed Luis? And he's sitting right behind me right now. The same person whose behavior and demeanor had changed in the weeks leading up to the murder. And the testimony that we shows he was thinking about Luis. So if murder did have to be shown, then that would be an indication that something had shifted, possibly toward. Were the two men friendly? That's what we heard. Was there tension? Was there disagreement? Was there conflict between the two men? We definitely heard that too. Again, even though motive is not something we have to prove, you can and should consider that it was the defendant who is the only one that you have heard has any motive to kill Luis. And again, it's an ugly truth, but we know it's a truth. People do terrible things sometimes for no good reason. No reason at all. During the argument that you heard just a few minutes ago, Attorney Harwood presented a theory, great theory, but it was without evidence. Pure speculation. Appointments, except when his grandparents would pick him up to do service in the nursing home on Mondays, or they would drive at nighttime to prayer or Bible studies. That's what we heard. He was in the house with Luis on October 1st, 2019, with nowhere else that he was supposed to be. That is evidence. Just like it's evidence that the house was secure and there was no sign of forced entry. We looked at every single one of those windows, every single one of those doors. And the killer didn't have to break in to kill his victim because they were both already there. The killer was already there, and so was the weapon that the killer used. And you heard that that gun was the gun to kill Luis. A gun that belonged to the defendant. This weapon was his gun. Nobody else. Certainly not the mystery man that they want you to believe in. Who would what? Break into a home, use a gun to shoot a person painting, then leave the gun and walk away? You heard the evidence and you saw the photos. Nobody broke into the defendant's house, let alone broke into the defendant's locked cabinet and used his gun to kill the victim. The key we looked at a minute ago, we've never heard any testimony from any witness that that was the key that opened up that particular cabinet. That's because the killer used his key to open that cabinet next to his pillow and get his gun, and in the process left his fingerprints on that gun. Then walked right around the corner into Danielle's old bedroom, now Mark's office space, and aimed the end of that barrel that we know is a couple of inches to no more than 12. From Dr. Duval, we know that's the distance between the end of that barrel and the back of Luis's neck. And the gunshot fired straight across his body, his spinal cord, right dead in the middle of the center of his body. It wasn't some mystery person that did this and left no trace. What? Obtaining the gun from the locked cabinet that he doesn't know where the key is, shooting Luis, then leaving the gun, then leaving the house locked, sneaking out without locking down anything. Shelves, post-it board, box. If you look, basket, perched off center at the top. Shot Luis, didn't disturb anything, didn't leave anything, and then disappeared without a trace. It was the defendant who got his gun and loaded it and made it ready and had plenty of time to do it that day because his victim was coming to him. The defense wants you to speculate on when this happened, saying somebody could have come by between Luis getting there and Danielle and Fran being told about the key so that they could finally get inside. But we know from his phone that Luis was on the phone with Minister Eddie from the church starting at 7:45. Remember, it goes for 28 minutes and a few seconds. Hung up his phone at 8:14 a.m. When Mark tries to call him, Luis doesn't pick up. When the defendant doesn't pick up, Luis continues to never pick up. That's at 9:30. That's 76 minutes. Within 76 minutes of his arrival, Luis is not picking up the phone like he usually does. That's not speculation, that's evidence. And Mark told us how he knew Luis was coming over that day. That's why he put the key under the mat. He did it just for Luis. There's no evidence that somebody else in 76 minutes that morning came over, found this key, went inside and did this. Something is wrong in that time period. You know that from more than just the jail calls too. Exhibit 7. We can see from the photo that the sanding block's fallen there at his feet. The wall's being prepared, right? The room is ready to paint, drop cloths are out, but he hasn't started painting the walls yet. You know he's dead because his hands are as clean as a whistle. Anybody who's ever picked up a roller or a brush knows there are no flecks of paint on Luis's hands. His workday had just barely begun when he was killed. That's not speculation. That's evidence of when this happened. Defense wants you to speculate that the defendant's failure to answer his own phone when called wasn't because he was avoiding discovery of his crime, but because he was praying so intensely and he just shut out the world for hours. But what's the evidence? We know what's wrong at 9:30. So 9:30, 10:30, 11:30, 12:30, 1:30, almost 2:30. Remember, Officer Phillips testified that he received that initial dispatch to get there at around 2:28 in the afternoon. So we can call that about 2:30. So for 5 hours. Prayer so devout that he didn't respond to any external stimuli for 5 hours. What was he praying for? Help, one would think. But he didn't call 911. He didn't do anything for 5+ hours. The physical evidence shows that he didn't do anything to help Luis at all. Look at the photos of the crime scene when you're deliberating. None of that blood was stepped in or moved or splashed before the police got there and got around the defendant to Luis. No one got Luis's blood all over them, the mystery man. The defendant didn't go anywhere for help. Mark testified that he believed, well, the second car was leased at one point, but then maybe not. Police didn't see any second car there. Fran told you she was there.
Objection, facts not in evidence.
The jury will use its own recollection of what the facts were.
Thank you, Your
As
Honor.
I've already instructed the jury.
The police didn't see any second car there, and no car was reported missing, stolen. So he didn't leave in a car, and no one stole one from him. The defendant didn't even put on his shoes to go get help. He didn't respond to the banging doors. He didn't respond to the front door, the back door, the doorbell ringing again and again. He didn't respond to acorns being thrown at the window. Brandon, are you all right? Garcia, are you okay? Brandon, Luis. Again and again and again, and the defendant does nothing. That's not speculation. That's evidence. That's the evidence of his actions. That's evidence of why he never responded to those calls, to the bangs, to the knocks, to the rings, to the acorns. It was because he intended for Luis to get shot with his gun. And he did it knowing the natural consequences of shooting anyone or anything in the back of the head, that Luis would die. That's evidence that this devout man, prayerful man, did nothing to help Luis. His bullets loaded into that gun, loaded into the chamber by pulling the slide inside his house, shooting Luis in the head. And not only is there no physical evidence to suggest that there isn't another person present, but why he didn't answer his phone is simple. He didn't want to get help for Luis. His failure to answer the phone was voluntary. He did what he wanted. He did nothing. Just like he fired because he wanted. He shot because he knew what would happen. For the defense to now come in here and cast aspersions and ask you to speculate that he was so devout, all he could do was drop on his knees when he found Luis. 5 hours. 5+ hours. When police are finally called, when Fran and Danielle discover the horrible truth. And while some mystery killer is out there, had put down the gun and walked away, to believe that is not reasonable. That is desperation for an explanation to a senseless act. Common sense tells you that the devout man who has a stranger enter his home and has murdered a minister who is trying to help him helps Luis. First aid, 911, run for help, stop the bleeding, something, anything. And the defendant did nothing. He did nothing because there was no other person there. There was no mystery man. There was the defendant, his 9mm bullet, his 9mm casing, his 9mm gun with his fingerprints and no one else's. His bullet doing exactly what he knew it was going to do. Now, the defense wants you to speculate about a couple other things too. Wants you to speculate about the swabs from the gun's grip or on the trigger, that it would have shown that the defendant was not the shooter. That touch DNA could have been left there by the mystery killer after he got the defendant's gun from the defendant's cabinet or from 2 zipped up bags down the hall, which he then would have zipped up on his way back out but left the gun there. Or that the GSR residue would not have been found on the defendant's hands or the clothing. He wants you to speculate that there could have been some information on the defendant's phone that showed that somebody else could have been coming over to the house to meet with the defendant. We heard that in opening. And then it was to meet with Luis. We heard that in closings. And that's the person, or those are the persons, who could have shot Luis. And at last, if the government had just tested those swabs, checked the swabs from the hand, grabbed that phone, those tests would have revealed that the defendant did not do this. All of that is speculation, designed to make you look anywhere else but at this man. The evidence in the real world, even on each of those things, points at this defendant. So let's talk about the gun swaps first. Let's break this down. Investigators knew that the defendant had definitely touched his gun. Fingerprints came back. Fingerprints testing showing the defendant's prints on the gun. And I'm not going to take my time going through it, but you recall some of those images that we looked at with specifically criminal hysteria. Bias on all of those dots, all of those color lines, 3 different levels of confirmation to be able to find out that that is in fact his fingerprint. Bias there. The fingerprint showed the defendant tested the prints, or defendant's prints were on the gun, and not just anywhere on the gun, but at the top of the slide. And here. Right near that clock symbol. Prints left by the skin and the residue and the oils that are on everybody's hands. Hands which are made of what? Blood, bone, and skin. Hence, hands filled with DNA. The defendant kept this case in his lock cabinet in his bedside table in his bedroom next to his bed. And we know from Mark Castiglione that a few days or a week before he went shooting with Luis at a gun range. And then, of course, the gun is found by the police in the defendant's house on top of those white cabinets that are there at the end of the hall, feet away from the bullet casing that we know the gun fired. Outside the bedroom, laying on that shelving unit. Now think about it. We know Officer Verrier touched the gun to make it safe initially. We know that. And even in that brief interaction, Officer Verrier's fingerprints were never identified on this gun. The theory that DNA testing on the pistol grip is going to change everything does not ring true, because it's a flawed theory. Because there's no evidence presented that suggests that a stranger was in the house and did this. A house that's filled with, that the gun sits in, the defendant's own DNA. So to think that DNA swabs would show that a mystery killer instead of the defendant's own DNA, it's not reasonable. The GSR swabs. Let's talk about those two for a minute. To think that the results of the GSR swabs would upend everything is also similarly unreasonable. Because the defendant's theory is that the police should have tested it, and if they did, they would have seen that there was no GSR on the defendant's hands or on his clothing, and he could not have been the one to fire the gun. That's what we heard as an argument a moment ago. What do we hear for testimony, though? What was the evidence? That when GSR comes out from behind the bullet, it opens up in a cloud. And as you heard from criminal hysteria, can expand out to approximately up to 6 feet. This is a small bedroom. The defendant is found laying on the floor of the room. Luis was shot. Collapsed. Roughly here, below that little white circle around the bottom. You heard that testimony from Francis Pastana. You heard that testimony from Danielle Potovano. You heard that testimony from the 2 Londonderry officers who went in initially. So he's laying on the floor with the casing that held the gunpowder right next to him. Luis's body, 3 feet away. The bullet coming to a rest, 2 feet away. The barrel of the gun that fired that bullet, 6.5 feet away. When Danielle saw him on the ground, he would have been laying in that GSR right there on the ground. To speculate that testing from the swabs, both from his hands and clothing, 12 hours later at the police department, would have shown that he had no GSR on him after he was found lying down in the spot where the gunshot was fired, that defies real-world logic of where GSR fell. To think that the results of that test would somehow show that he conclusively was not the shooter, that's not reasonable. Finally, let's talk about the defendant's phone. In what must be the first time that somebody said, "You should have seized my phone from me." And my phone that I own, that would have shown that somebody else did this. You heard from Sergeant McCauley and Lieutenant O'Leary that in this state, police cannot just seize whatever they want, whenever they want. They need probable cause to apply for a search warrant, right, that they have to have probable cause that evidence would be seized in or on the item that's taken. It's written that way in our Constitution. They have to follow the authorization that they were given when they were executing the search warrants they had. And you saw evidence of that. When we looked at the details of Luis Garcia's phone, it was only because Patricia Garcia had given permission for that to be analyzed, a consent to that search. There's no evidence that somebody else was involved in the crime. So there's no evidence for police to be able to seize or search the defendant's phone. And these arguments just a moment ago, the defendant, where he was that day. What, he left the house in his socks that day? He just went where? Nowhere. That there was somebody else who went in and could have gotten that gun not out of the locked cabinet, but out of the bag in the hallway. The bag that was sealed up when police got there. So the defendant came in, I'm sorry, not the defendant, the mystery man comes in, opens his bag, opens the second bag within the bag, and could have taken the gun out of this bag, even though that was not the testimony about where Brandon kept that gun. And the casings, well, should have looked at these casings too. They could have been consistent. JGO2 specifically states Exhibit 112. The 9mm bullet, excuse me, casing that fired the bullet that killed Luis Garcia. And the defendant's exhibit of the casings in the bag. Notice everything different about the end? It's not even the same height of casing. Your eyes can show you that. One that has the additional space around the outside. One that doesn't have a primer ending that looks like this. These aren't even the same type of casing. You don't need to be an expert to see that. So, we've discussed the defendant's theories. We discussed what the defendant did to Luis when he shot and he killed him. Now, let's look at what all of that means under the law. Judge Ruoff will explain the law to you, what it means to commit second-degree murder, both knowingly and recklessly. And lesser included crimes, if you consider those two, decide that he is not guilty and then move on. In deliberations, you should consider the following, though, when you're discussing the charge of second-degree murder. You've got to decide whether the defendant caused Luis's death, and that the defendant who pulled the trigger on that gun, and we know the person who pulled the trigger on that gun, is the one responsible for Luis's death. That gun that belonged to the defendant, his ammunition, his locked bedside table, his fingerprints. And for the variation of second-degree murder with a knowing intent, you also have to consider whether the defendant acted with a knowing intent to cause Luis's death, in that he fired aware that his conduct would cause Luis's death. That intent. When you've heard how Luis was shot, back of the head, through the center, the end of the barrel mere inches away from his head, and he fell and dropped on the spot. And when you heard about how the defendant was found, on the ground, mumbling by his sister and his poor grandmother, having to find the key to get inside the locked house, you should consider all of that when deciding whether the defendant knew that he would cause Luis's death by shooting him that day. Similarly, you should consider, when you consider whether he pulled the trigger, that he acted with extreme indifference to the value of human life. He had gone shooting with Mark before. He had been with Luis before, you heard, in just a couple of weeks or days before the crime. He clearly knew how to use the gun. He'd owned it for a while. He knew its deadly potential. So he knew that when he aimed and pulled the trigger at Luis, what was going to happen. And when you consider intent, remember what we learned about the gun itself. This gun is not susceptible to jar off, so this is not an accident. The gun slide pulls to load a bullet into the chamber. Slide that we have, of course, with the defendant's left thumbprint right on it. Defense a few minutes ago talked about that Brandon had 15 rounds, one here, 14 in the magazine, one there, that's 15, that's all the magazine holds. 15. Gun can't hold more than 15, that's it, 15. You heard Sergeant McCauley testify, didn't you? Sergeant, how do you carry it? My magazine holds 10. How do you carry it? I carry it with 11. How? He tops off. He puts one in, loads it in the chamber, and then puts another one in the magazine and reloads it. That's how Sergeant McCauley carries his gun. That's how a police officer has testified how he carries a firearm. That 14 left in the magazine, one in the chamber, and the +1, that's the one in the back of Lewis's head. That went through the back of Lewis's head. And the trigger itself, how you know it's not an accident. When you think about whether he had the intent to kill, it's a two-part trigger mechanism. It's not an accident to fire this gun. You'll be able to examine this in there. You have to want it. You have to get your finger all the way in there to pull it. This is not just a whoops. This is not just a slip. This is not just, I want to show you something that we went shooting together a couple weeks ago or a couple days ago, and you've seen me do this plenty of times. This is no mistake. When you consider intent, and remember also what we learned about where Luis was shot, back of the head, through the neck, that morning he didn't see this coming. He couldn't use his hands to defend himself. He was facing a wall with his back to the killer. When you consider intent, remember what we learned about what the defendant did, again, after Luis was shot. Nothing. His actions afterwards also reflect his intent, that he knew what would happen and that he caused Luis's death. He didn't call. And lastly, remember what we know about this defendant when you think about intent. A man who knew firearms and knew how to keep them safe. His familiarity with that weapon was unquestioned. He even held on to the booklet. There's no simple recklessness here. There's no negligence here with a firearm. He knew what his bullet could do, and he knew what his bullet would do. And when you consider the intent, remember one more thing. The bullet. This bullet, Exhibit 73A. The bullet that went through Luis's body and struck this wall and collapsed down onto the ground, which caused Luis to collapse down onto the ground. When you have to consider what the defendant's intent was, I want you to consider this bullet. A hollow point bullet, which you heard from Gilterio, is designed to open up on impact, and they have little petals that look like almost like a flower. This bullet that made Luis instantly drop. His spinal cord sending signals to that spot in his neck, pulpified, obliterated, gone. He cannot breathe. And he bled for as long as his heart could keep going before the oxygen deprivation stopped it altogether. You heard from Dr. Duvall. He may have been unconscious. One would hope that he was. Because the alternative is horrific. That this man, who had asthma so bad that he couldn't work in a packaging plant anymore, had to leave that refrigerated environment, may have died conscious, aware, and unable to breathe. And the defendant did nothing to help him. The blood stayed where it fell. So, it's not tracked all over the floor. It's not all over the defendant. You won't see any of Luis's blood on him in his booking photos, not on his jeans, not on his arms or his shirt, and not on his clean white socks. And he was so wrapped up in prayer for Luis that he didn't hear anyone call, pound on the doors, ring the bell, throw acorn or anything. He didn't take one step near Luis. Think about that when you look at that bullet and when you decide whether or not this defendant had the intent to shoot Luis in the head and knew that it was going to result in his death. Also, we told you at the beginning that you bring your common sense here with you into the courthouse. You don't lose that. You don't abandon that. Jill Terrill testified that an all-copper bullet was unusual. In her nearly, 20 years of firearm examination, she was unfamiliar with it. And she had to look it up. The casing and the bullet, after it had been delivered to her, she had to look that up. Fiocchi, all copper, 90 millimeter, from the defendant's box, typically a very light 92 grain bullet, give or take a few tenths of the gram is what we heard, from the manufacturer. A unique round that the criminalist, who had, again, almost 20 years experience, after working at places like Miami, New Haven, Connecticut, had to go ahead and look this up. And the spent bullet weighed what? 84 grams. 84 grams. It appeared to be missing two petals. Two petals of this hollow point jacket that pushed open when it hit, mushrooming open, causing even more damage inside. And the two petals left behind by this bullet's jacket when it went through its target, you see those two petals are. Right in Luis's neck. The whole back and forth over whether this bullet could have been fired by some other six-line polygonal right-hand twist. The bullet that killed Luis was fired by the defendant's gun. That's a fact. So even if he wants to say it's from some other person or some other gun, the casing is from his gun. The bullet is from that box of ammunition. There's no other bullet in the room. Not in Luis, not anywhere. None. Just the one. Think about that when you think about intent. That bullet from that case that follows evidence. Evidence that this man knew what was going to happen when he put that gun and aimed it at the back of Luis's head. He fired his bullet and he hit his intended target. All the speculation on coulds, mays, you've now seen that it is just that, pure speculation. It's not reasonable. It's not based upon the evidence. If we're going to quote Ben Franklin, let's do it right. Facts are stubborn things. And the facts have been shown in this case. That this man here and these hands that never got a chance to paint that day, hands that never got a chance to defend himself, hands that never got a chance to pray with someone one last time, the hands that worked, that cooked, that prayed, that loved, that counseled, that gave service to others, that tried to counsel, tried to help this defendant. And then this man, took out that gun with his ammunition, pulled back that slide, aimed it back of Luis's head, and pulled the trigger. Because there were only 2 men inside that locked house, and only one man knew what was coming. This is not jumping to conclusions. It's called following the evidence to where it leads. And all of the evidence leads to one clear and logical conclusion beyond all reasonable doubt. The defendant's bullet, the defendant's casing, the defendant's gun with the defendant's fingerprints firing a bullet into the back of Luis's head inside the defendant's house. What the defendant did was murder. Plain and simple. He committed a murder. He got his gun from the locked cabinet, loaded it with his hands, aimed it at the back of Luis's head from as few as a couple inches to as much as 12 inches away, and he executed him. He executed Luis. No one is jumping to any conclusions. The evidence, physical and testimonial, from his family, from his neighbor, from lay persons, experts, all demonstrated a clear path to the only logical conclusion beyond all reasonable doubt, that the defendant murdered Luis Garcia. That makes him a killer. The defendant may have been found with his hands together, praying, when his mother and his grandmother were finally able to get into that house hours later, when everything went radio silent. Hours after, and even while those phone calls from Pat G were still coming in and nobody was picking up. But his hands, those murderous hands, now we know, God knows, he was not praying for Luis. Return the only verdict that is consistent with justice in this case. Find that man guilty of second-degree murder. Thank you very much for your time.
Thank you, counsel. Ladies and gentlemen, now that the trial in this matter is concluded, I will give you further instructions that apply to this case. At the beginning of the case, I gave you instructions about a number of issues that typically come up during the course of the trial. Remember, all the instructions I have given you throughout the case should be considered as a whole, so do not single out any particular instruction for special emphasis. As I told you at the outset, you'll have a complete written copy of my instructions with you in the jury deliberation room. You have heard the opinion testimony of expert witnesses in this case. An expert is someone who has acquired some specialized knowledge, such as scientific or technical knowledge, from experience, training, or education that qualifies the expert to give an opinion as to matters that are not common knowledge. The opinion of the expert may assist you in understanding the evidence or in deciding a factual issue. You are not bound by the opinion of an expert. You are free to ignore the expert's opinion if you find that the reasons given in support of the opinion are not sound, or if you find that other evidence outweighs the opinion. Now, I'm going to discuss the definition of the crime upon which you must now deliberate. Both indictments in this case are alternative indictments. Alternative indictments allege different legal descriptions of the same crime. Charge ID number 180539C alleges the defendant committed the crime of second-degree murder in that he did knowingly cause the death of Luis Garcia by shooting Mr. Garcia through the neck with a firearm, resulting in his death. In order to convict the defendant of this crime, the state must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of another. And 2, that he acted knowingly when he did so. Part of the definition of this crime is that the defendant acted knowingly. Under the law, a person acts knowingly with respect to conduct or to a circumstance that is a material element of an offense when he is aware that his conduct is of such a nature or that such circumstances exist. In the context of this indictment, the state has to prove that the defendant was aware that his conduct would cause the death of Luis Garcia. The state does not have to prove that the defendant specifically intended to cause the death. Charge ID number 1674110C alleges that the defendant committed the crime of second-degree murder in that he did recklessly cause the death of Luis Garcia under circumstances manifesting an extreme indifference to the value of human life by shooting Mr. Garcia in the neck with a firearm, resulting in his death. In order to convict the defendant of this crime, the state must prove the following elements beyond a reasonable doubt: that the defendant caused the death of another, and that the defendant acted recklessly under circumstances that manifested an extreme indifference to the value of human life when he did so. The term recklessly has a specific legal definition in criminal law. A person acts recklessly with respect to a material element of an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the material element exists or will result from his conduct. The risk must be of such a nature and degree that, considering the circumstances known to him, its disregard constitutes a gross deviation from the conduct of a law-abiding person that would observe in the same situation. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find that the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from what a law-abiding person would have done under the same circumstances. However, with respect to the crime of second-degree murder, the defendant must not simply act recklessly, but rather must act recklessly under circumstances showing an extreme indifference to the value of human life. This means something more than mere being aware of and consciously disregarding a substantial and unjustifiable risk of death. The risk involved and the disregard must be so blatant as to manifest extreme indifference to the value of human life. As noted earlier, these are alternative indictments. You are required to deliberate on each charge separately and independently. Your verdict on one charge should not influence your deliberation and verdict on the other charge. If you find that the defendant is not guilty of the crime of second-degree murder in both alternative indictments, then you should go on to consider and decide whether he is guilty of a similar but less serious crime. But you only do so if you find him not guilty on both alternative indictments. If you find him guilty on one or both second-degree murder indictments, you do not deliberate on the lesser offense. A similar but less serious crime is different from a more serious crime in one of two ways. Either it requires a less serious physical act, or it requires a less serious mental intent. Here, if you decide that the defendant is not guilty of second-degree murder, then you should consider whether whether the state has proven beyond a reasonable doubt that he is guilty of the similar but less serious crime of convict the defendant. In order to convict the defendant of manslaughter, the state must prove beyond a reasonable doubt that the defendant caused the death of another slave. Has the same definition as described above, but without the requirement to prove circumstances that manifested extreme indifference to the value of human life. If you find the defendant not guilty on the lesser charge of manslaughter, then you must decide whether the defendant is guilty of the lesser offense of negligent homicide. In order to convict the defendant of negligent homicide, the state must prove beyond a reasonable doubt, 1, that the defendant caused the death of another person, and 2, that he did so negligently. The term negligently has a specific legal definition in criminal law. A person acts negligently when he fails to become aware of a substantial and unjustifiable risk that his conduct would cause a particular result. The risk must be of such a nature and degree that his failure to become aware of it constitutes a gross deviation from the conduct that a reasonable person would observe in the situation. Now, some of you may be familiar with negligence in civil cases where one person sues another for allegedly causing harm. The standard for negligence in such cases is lower than the standards for negligence in criminal cases, and the two standards should not be confused. Negligence in a civil case is simply the failure to exercise the degree of care that a reasonable person would exercise under the same circumstances. In a criminal case like this one, Proof of negligence requires evidence that the risk was more than an ordinary risk. It requires proof that the risk was substantial and unjustifiable, and that the defendant's failure to become aware of the risk was a gross deviation from how a reasonable person would have acted in the same situation. Keep in mind that there is often no direct evidence of intent, because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances and evidence in determining whether or not the state has proved that the defendant acted knowingly, recklessly, or negligently in this case. Now, the principles of law that I've given you are intended to guide you in reaching a fair result in this case, which is important to both the parties in the courtroom and to the court. You are to exercise your judgment and your common sense, as I said before, without passion, without prejudice, without sympathy, but with honesty, understanding, and due deliberation. The law demands that you make a fair decision based solely on the evidence, your individual evaluations of that evidence, and your reason and common sense in these instructions. When you have considered and weighed all of the evidence, you must make one of the following findings with respect to each charge that is before you. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the offense charged, you must find the defendant not guilty. However, if you find that the state has proved all the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. Keep in mind, you are required to deliberate on each charge separately. Now that all the evidence is in and the arguments are completed, you will be free to talk about the case in the jury room. In fact, it is your duty to talk with each other about the evidence and to make every reasonable effort you can to reach a unanimous agreement. Talk with each other, listen carefully and respectfully to each other's views, and keep an open mind as you listen to what your fellow jurors have to say. Should any member of the jury panel leave the deliberation room for any purpose, use the bathroom or take a break, you should stop your deliberations. You should only deliberate when all deliberating jurors are present to hear and participate in the discussion. Your verdict must be unanimous. All 12 jurors must agree on your verdict. When you have arrived at your verdict, let the bailiff know, and you will be returned to the courtroom where the foreperson will render that verdict orally in response to questions that the clerk of court will ask you. To assist you in that process, you will have a verdict form to fill out. The foreperson, who you will select as your first order of business, should see to it that the jury takes up the issues that are before you. The foreperson should see to it that each juror has a full, fair, and an adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. If any questions should arise during your deliberations, the foreperson should write the questions out, hand them to the bailiff, and they will be brought to me. I will respond accordingly to those questions. I want to thank you for your attention. I'm now going to select the alternate jurors. I have to pick two because only 12 jurors can actually deliberate at one time. I want to thank the alternate for their service. In a moment when we recess, I'd like to see both alternates at the bench. With respect to the jury verdict form, this will be what the jury foreperson will have to fill out, and itself it kind of explains itself as I gave you in the instructions. You only proceed to the lesser included offenses if the jury unanimously finds the defendant not guilty on the second-degree murder alternative indictments. Counsel, anything before I pick the alternates?
Not from the defense, Your Honor.
No, Your Honor.
Okay. I have a 20-sided die here that I use to pick the alternates from. It's from my son's Dungeons and Dragons set. So alternate number 1, juror number 4, Miss Enos. Juror number 7. I'm going to have the two of you approach. It's going to take a few seconds for the monitor to get the exhibits together with you. Our policy is that we do not allow guns and ammunition in the jury deliberation room at the same time. So I'll confer with counsel about which one to send in the deliberation room. And but I'll have the jurors please approach. Alternates, come on up. Other than that, as soon as you select seated. All right, ladies and gentlemen, I'm told that we have received a verdict in this case. I'm going to bring the jury in a second. Just want to remind everybody that the return of a verdict in every criminal case is a very serious event. Obviously, this is a serious matter, and it has been well tried by both sides. I just ask that the solemnity. Okay. Mr. Sharp, bring the jury. All rise to the jury, please.
You may be seated.
Thank you, ladies and gentlemen. Madam Foreperson, I am told that the jury has reached a unanimous verdict in this case. Is that true?
It is.
Okay. Have you reached a verdict on both of the indictments that are pending?
We have.
Okay. Madam Clerk?
Will the defendant remain standing and face the jury? Madam Foreperson, please stand. Madam Foreperson, how say you? Is the defendant guilty or not guilty of the charge of second-degree murder, charge ID number 180-9C, alleging that the defendant committed the crime of second-degree murder in that he knowingly caused the death of Luis Garcia by shooting Mr. Garcia through the neck with a firearm, resulting in his death?
We find the defendant guilty.
The foreperson has said guilty as to that charge. So say you all, ladies and gentlemen of the jury?
Yes.
Madam Foreperson, how say you? Is the defendant guilty or not guilty of the charge of second-degree murder, charge ID number 167C, crime of second-degree murder in that he recklessly caused the death of Luis Garcia under circumstances manifesting an extreme indifference to the value of human life by shooting Mr. Garcia in the neck with a firearm, resulting in his death?
We find the defendant guilty.
The foreperson has said guilty as to that charge. So say you all, ladies and gentlemen of the jury?
Yes.
Thank you.
Okay, thank you. Madam Foreperson, may I see the jury verdict form, please? The form is in order. Thank you. Counsel, would you like the jury polled?
Yes, Your Honor.
Okay. What I'll do is I'll have the jury polled now. What that means is that the clerk is going to ask each individual juror with respect to, since the finding is guilty on both charges, so we'll have them polled for both charges at the same time, since they're alternative indictments. So when the clerk reads your jury number, you're to let us know orally, each one of you individually, what your verdict is with respect to both charges. Madam Clerk.
Thank you. Madam Foreperson has announced a guilty verdict. Madam Foreperson, as to both charges, how say you? Is the defendant guilty or not guilty?
Guilty.
Juror number 2.
Guilty.
Juror number 4. Oh, is alternate, my apologies. Juror number 5.
Guilty.
Juror number 6.
Guilty.
Juror number 8.
Guilty.
Juror number 9.
Guilty.
Juror number 10.
Guilty.
Juror number 11.
Guilty.
Juror number 12.
Guilty.
Juror number 13.
Guilty.
Juror number 14.
Guilty.
And juror number 15.
Guilty.
Thank you.
Thank you. Defense, please be seated. All right, ladies and gentlemen, thank you for your service. I'm going to discharge you at this point in time, but ask you to remain in the jury deliberation room for a few minutes while I deal with some administrative matters here in the courtroom. Mr. Bailiff, if you would please bring the alternates back with the 12 deliberating jurors. Thank you. All rise for the jury, please. please be seated. Verdicts of guilty having been entered, the defendant is convicted of the second-degree murder. Bail is revoked pending sentencing. We'll schedule sentencing. The clerk will reach out to the parties at some point and figure out a mutually agreeable date for sentencing in this matter. I will be requesting a PSI, pre-sentence investigation report to the Department of Corrections, and we'll schedule this for sentencing as the next order of business. Anything further from the state?
Nothing else, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, I'll issue that order. Court stands in recess. Thank you.
All rise.